There it is.
Mr. Havgood,
My Lord,
glad to see you on your feet.
Yeah, thank you very much. My Lord, one or two points to pick up from this morning. First of all, my Lord Sumption mentioned El Arju. I don't propose to go to Sir Justice Miller's decision in that, but could I show you briefly what he said about that decision in his first instance decision in the Macmillan case? I think we'll have to hand that up.
I think it's been handed up.
Okay, good. We need, please, report page 9898.
Thank you.
And it's really only a few sentences at the foot of the page. In the course of argument, it was submitted by Macmillan that this is inconsistent with my decision of my own in El Arju v. Dollarland Holdings. In my judgment, there is no similarity between the two cases. In El Arju case, the plaintiff brought an action to recover the proceeds of a fraud committed abroad, and which the plaintiff claimed to trace to several foreign jurisdictions before they were finally received by the defendant in England. I rejected its submission that the plaintiff could not trace inequity through civil law jurisdictions which did not recognise the concept of equitable ownership, as one, the plaintiff's claim was a receipt-based restitutionary claim to recover money which had been received in England and was accordingly governed by English law, and two, the ability of a plaintiff to trace inequity is dependent on the power of equity to charge a mixed fund with repayment of trust money and not on any actual exercise of that power. That case was concerned with tracing, not title. And then going down to the paragraph just below D, in my judgment, Macmillan's claim is properly to be characterised as a restitutionary claim which depends upon establishing a continuing proprietary interest in the subject matter of the claim. So I think El Arju, it's obviously a very interesting case, but it doesn't bear on, I think it doesn't bear on this particular case.
I think it's a very slender distinction.
Next, Lord Collins asked a number of questions this morning about recognition and whether certain passages we cited went to recognition, and some of them do. But this appeal is not about recognition, it's about Article 4 and Article 15. We drew those passages to your attention because I do think they do cast light on the overall scheme of the Convention. And so, although it's a perfectly fair point to take against us, that they're not exactly directly in point, I think they give you some assistance. And then the last point I want to pick up...
All I had in mind was that it does throw doubt on your suggestion that the Convention was not intended to change the position in civil law countries when looked at from the standpoint of common law countries, because what most of those passages were about was whether the effect of the recognition provisions was to force civil law countries to recognise things that they were not happy.
And I think they're all to the same effect, that it was not intended to force civil law jurisdictions to do anything against their will. Yes. As it happens, the Convention has, by a side wind, so to speak, had the effect of encouraging a lot of civil law jurisdictions to look at this whole question and to decide, well, actually, we will introduce a fiduciary patrimony, whereas before we had none, knowing that, in a sense, that makes the Convention more reciprocal. Because I think the benefit to the Convention was originally, no doubt, accurately stated by Professor von Overbeck, but I think he understated it because he didn't appreciate the development that was going to take place thereafter. Now, lastly, if you can stand it, one more passage from Hayton. It's cited in our case at paragraph 89. It's in volume 8, tab 83, MS3, MS 3471.
Three, 4, 7, 1.
Yes, 3471.
Yep.
This is an article by Professor Hayton which appears in the International and Comparative Law Quarterly 1987. And at 3471, under the heading For Launching the Trust, Preliminary Issues, can I go to the second paragraph within that?
Yes.
A trust may be created either by the settlor transferring specific assets to trustees for specified purposes, or declaring himself trustee for specified purposes of assets specifically appropriated for the purpose of the trust. The question of the validity of such transfer or declaration is outside the Convention, though once the trust has been created by either method, the Convention applies. Thus, if a Frenchman purported to declare himself trustee of specific French movables for certain English beneficiaries and stated that English law was to be the applicable law, the Convention would not apply to the preliminary issue of the validity of the declaration of trust, which would be ineffective by French law under English conflict rules. And then he gives the obvious example of a Queenslander dealing with Queensland assets. And these, the importance of articles of this sort by Professor Hayton, obviously over the years, Professor Hayton has expressed slightly differing views. His prerogative, he looks at it from time to time. But these, in 1987, the Professor von Oberbeck report and what David Hayton had said as a delegate to the drafting commission, and what he said in contemporaneous articles like this, was all very much of a one, and that was that there are preliminary acts which involve the validity of acts taken to establish the trust, and we say that that validity includes the question of whether there is an interest capable of being put into the trust at all. Now, let me next come on, I'm going to take this quite briefly, to the Rangers' decision.
Yep.
That's at Authorities Volume 1, Tab 6, MS 1165. Now, the background facts was that Rangers Football Club needed to raise some finance, and for this purpose it entered into a season ticket agreement with a ticketing company called Ticketus, by which Rangers sold and was paid up front for certain tickets to Rangers matches over a 4-year future period. However, the tickets themselves were to be marketed to the public by Rangers under an agency agreement, and Rangers was to account to Ticketus for the sale proceeds. And both those contractual arrangements, the STA, that's the season ticket agreement, and the agency agreement, were governed by English law. Now, when the proceeds of sale of those future matches came in, Rangers, or the administrators of Rangers, declined to account to Ticketus for the proceeds. And the evidence was, and if you please go to paragraph 17 in the report at page 1171, there was expert advice from Richard Hacker QC on English law, and that was to the effect that the season ticket agreement gave rise to more than a mere personal right. So ticketers had a right to the proceeds in Rangers administration. So that was the position under English law. The position under Scottish law was recorded by Lord Hodge at paragraph 33 on page 1174. Lord Hodge said, if I'm correct in my conclusion that Scots law applies, the difficulty which ticketers faces in asserting a trust over the proceeds of sale of the STA tickets is that the proceeds do not yet exist. On the assumption that the ticketers' agreements are sufficient to amount to a declaration by rangers of a trust over the STA tickets and the proceeds of their sale, the non-existence of both is fatal to the creation of a trust. Where the truster and the trustee are the same person, it is our law that there must be constructive delivery of the trust subjects to himself as trustee of an irrevocable trust. And he there cites some authorities. Now, on Mr. Howard's...
he goes on to say that, and that can't happen because under Scots law, there has to be an actual asset.
There has been actual asset, yes. Now, on Mr. Howard's approach to this, he'd say, issues of title are all governed by the governing law of the arrangements of the trusts. The governing law of the trusts was English law because the SDA and the agency agreement were governed by English law. And therefore, the question of whether ticketers had trust rights in relation to the sale proceeds is governed by English law. That, of course, is not what the outcome was. The outcome was very clear. It's recorded in paragraphs 24 and 25 and 26 of the judgment at 1172. Paragraph 24, Lord Hodge said, he's referred to paragraph 43 of an Obrecht report, I am therefore persuaded that the recognition of Trusts Act 1987 does not have the effect of making the law chosen by the settlor the governing law of the steps needed to create the trust. Were it otherwise, the assets would be startling, results would be startling, as a settlor would be able to alienate property which he could not dispose of under the lex situs. It would create significant problems for the operation of insolvency law in the jurisdiction in which the asset was located. And I rely upon all of that as correct and applicable in this case. Now, he then says in paragraph 25, as I've reached this view on Article 4, it is not strictly necessary to consider Article 15, but I'm inclined to accept counsel for the noter's submission that in the context of a convention which covered both civilian and common law systems, it would not be appropriate to take a technical view of the concept of property in Article 15d. It would therefore include the change in the capacity in which a person held assets if that change could have proprietary effects in an insolvency. And then paragraph 26, I conclude therefore that Scots law as a legal system under which the debts due on the sale of the SDA tickets have arisen and may arise governs a recognition of the trust which the agency agreement sought to create under English law. And those two paragraphs, 25, 26, again entirely support our case.
Yeah. I see.
Now, can I now turn to what I say are the errors in the Court of Appeal's judgment on the Article 4 issue? If I could please take you to the judgment. Sorry, it's Core Volume 2. We want paragraphs 50, starting at paragraph 50 in the judgment, which is (238). Yes, thank you.
50, sorry.
MS 238.
Yeah, thank you. Yep. Thank you.
Now, picking up the start of paragraph 50, it's important to start the evaluation of the parties' competing positions by reference to the words of Article 4 itself in the context of the entirety of the Convention. Article 8 makes clear that the law specified by Article 6 or 7 shall govern the validity of the trust, its construction, and its effects. Thus, one would not expect a trust governed by the law of a common law country to be invalidated because it's purported to transfer the beneficial interest in the trust property to the beneficiary. Moreover, Article 4 provides only that the Convention does not apply to preliminary issues relating to the validity of wills or other acts by virtue of which assets are transferred to the trustee. Those words in our judgment should be construed as meaning what they say, namely that the article is concerned with preliminary issues, as Professor von Oberbeck pointed out, relating to acts by virtue of which assets are transferred to the trustee. The declarations of trust do not actually or purportedly transfer anything to the trustee. Adopting the most purposive possible construction, one is forced to the conclusion that the line is to be drawn once the assets have been transferred to the trustee, whether or not that distinction is entirely logical for all purposes. And our answer to that is that, well, it lies in submissions my learned friend Mr. Green made this morning, that there is ample material that those who framed the Convention did intend that preliminary acts, or that concept, should apply in the case of a declaration of trust as well as the case of a settlement. Now,
and the point that seems to be being made here is that you have to distinguish between an issue about the validity of the trust once created and an issue about the validity of the legal act by which the trust or alleged trust acquires the assets.
yes.
And that this is a case about the validity of the trust. I mean, do you agree that that's what the Court of Appeal appear to be saying?
That's what I agree, that's what the Court of Appeal is saying.
I mean, you say that the Travo indicate that that wasn't what was intended, and at the moment I see the force of that. But what do you say about the language of the Act? I mean, it does on the face of it appear to be rather difficult to fit into the language of the Act, especially when you read 8 and 4 together. Language of the Convention, forgive me.
Well, I would say that 4 is drafted in broad language. I mean, it could have been set out much more precisely what's not covered by the Convention. But if you start from the concept that it's a two-stage process, we say that getting or launching the launcher process, getting the assets into the trust, if you say, we're saying in effect, a particular asset couldn't be launched, it wasn't capable of being launched, And so we say that's a stage 1 question.
What matters would fall under the reference to validity of the trust in Article 8, for example?
Yes. So, yes, certainty of objects, perpetuity,
Yes, I see.
private purpose trusts.
So you say it's more logical to say that if I transfer things to you on trust, that is, the transfer is covered by Article 2. If I constitute myself trustee, then the same rules should apply to
Yes.
whether I can do that.
Yes.
It shouldn't make any difference whether it's
It shouldn't make any difference at all.
self-dealing or dealing with someone else.
Yeah.
And the logic of the Court of Appeal's position appears to be that neither
Yeah.
would be covered.
But I was going to say, is the Court of Appeal saying neither is covered?
Neither or both. Yeah.
Yes. And when it says assets are transferred to the trustee, it means assets are transferred to the trustee to hold as such. That's why with a declaration of trust, he is notionally transferring from himself as beneficial owner to himself now as trustee.
So the Court of Appeal's analysis would involve saying that if I transfer to you held on trust, the transfer to you may be covered by Article 2, but the requirement to hold it on trust isn't, or what?
Well, if we have a settlement, which one can think of as tripartite, there's a transfer to a trustee.
Yeah.
With a declaration of trust, it is simply the legal estate doesn't move, but the capacity changes.
Yes.
And that makes that brings it into the same, that equates it to an ordinary settlement. Now, well, Mr. Rots has passed me a note which says the excluded issue, that's the issue excluded by Article 4, is the creation of a separate fund, either by division of ownership or by division of patrimony. Article 8 deals with internal relationships, i.e. the relationships between the trustee and the beneficiary once the trust has been constituted. I think that's
Yes.
another way of saying
That
the
would
same
be
thing.
consistent with the illustrations you gave a moment ago. Yes. Certainty of objects and perpetuity.
Yes. Now, can we move on to paragraph 51 of the judgment? We have no difficulty accepting the dictum of Lord Hodge in the Rangers case as explained in the latest views of Professors Hayton and Harris, where they opine that the lex situs must govern whether the trustee has the capacity to alienate the property at all. It would, as they say, make no sense to hold that a trust could be created by a person who owned inalienable property. But in our judgment, once it's clear that the trust property can be alienated in some form according to lex situs, that law cannot govern the trust or its validity or effects. All that must be a matter for the law identified by Chapter 2 of the Convention. Now, we say that that is just, first of all, it's not supported by authority, but we say that that is quite an illogical way of looking at the matter. The question is not whether the property could be alienated in some way, which didn't happen. The question is, could it be alienated in the way which did happen? And looking at other forms of possible transfer is neither here nor there. Indeed, in the Rangers case, I'll just give you the reference if I may. Yes, at paragraphs 35 to 37, that's MS 1174. Lord Hodge addressed a suggestion that the trust arrangement could have been effected by an assignation of future and as yet non-existent assets. And he said, well, that's all very interesting, but that's not what the parties did. He says in 37, this is not a complication which I have to address because, for reasons I set out above, I have included that ticketus is merely a contractual right through the STA and the agency agreement for the expected income, which is, when it's received by rangers, to be held in trust. That is not a trust right.
Before you referred to the statement of facts that under Saudi law there was no means of creating separate and legal and equitable proprietary interests, which is a sort of case of impossibility. But wasn't there evidence that under Saudi law it was prohibited from transferring property to foreigners without
Yes, there was
political consent, and that would have been a strong mandatory rule, wouldn't it? Why has that not been in play?
Was it disputed? Yes. Well, because the Court of Appeals said we needed more evidence to pursue it, I think. The answer.
Yes. Yes.
And then, carrying on with the Court of Appeals judgment,
Yes.
the Court of Appeal referred to the latest views of Professor Harris and Professor Hayton. Where is that? I lost my place. 51, is it? Yes, that is at paragraph 51. As explained in the latest views of Professor Hayden and Harris. Now, they cite various passages. Perhaps I could look at the Professor Harris passage cited at 44 of the Court of Appeals judgment, isn't it? Yes.
Isn't that Professor David Hayton?
That is...
Harris is 47.
It's Harris in Hayton, I think.
Harris wrote the chapter.
Yes.
Yes, it's Harris. You're
Yes.
Where do we find the quote in paragraph 44?
It's-
Where is it in the authorities?
It's AV9 at tab 100, MS 3880.
It is, yes. I see. So the general editor is David Hayton, but the
Yes.
passage is written by Harris.
Yes, exactly.
Perfect opportunity for confusion. Thank you. Yes.
And it's paragraph 100.21.
Point 121, do you mean?
MS 3880.
Yes, I think he does. Yeah, thank you. Yep.
Technically, one could argue that two questions arise as to the passing of property. One, the transfer of legal title to the trustee. Two, the transfer of equitable title to the beneficiary. However, civil law systems know nothing of equitable title, and once legal title has validly been transferred to B, the rocket launching process is concluded. It follows that the sole question with which the lex situs should concern itself is whether legal title to an interest may be alienated. It should not be a reason to invalidate the rocket launching process that the situs does not know the trust concept. The particular interest which a beneficiary acquires under the trust should be seen as an aspect of the relationship between trustee and beneficiary and governed by the applicable law of the trust as determined by the rules of the Hague's Trust Convention. In a common law country, a beneficiary will obtain an equitable proprietary interest binding third parties, but in a civil law country, not knowing such a proprietary interest, a beneficiary will only obtain a ring-fenced interest binding the trustees, creditors and heirs, but not third parties to whom the trustee had transferred a trust property.
Yeah.
Well, I say that at the most, in this case, Samba acquired an interest which was not a proprietary interest. Sickle acquired an interest which was not a proprietary interest, and all it obtained was a personal ring-fenced interest binding Sickle's creditors.
Yeah, but that phrase about ring-fenced interest is contrasting the position in the common law country with the position in the civil law country. It's not talking about the effect of conflict of laws rules.
Well, it's the paragraph is comparing the interests of a common law beneficiary with the interests of a beneficiary under a civil law trust in a civil law state, and that is the point here, that the interest which Sickle is claiming is an interest in an asset in a non-trust state. So, I mean, it cannot have got more than a ring-fenced claim against Mr. Al-Sneer. Yeah. Well, I took you this morning over the next tab at 3886. I mean, this is the most recent view of Professor Hayton, because it's a 2016 edition of Underhill and Hayton. Yes, and he wrote that chapter, Article 10. Thank you very much.
So which bit? It's the paragraph 3, isn't it?
Paragraph 3, yeah.
Yes.
Yeah. Now, last point on the Court of Appeal is on paragraph 55.
Yep. Cool, yeah.
If I can be quite blunt about this, we say this is just a frightful fudge. If we look sort of halfway through the paragraph at MS 239,
Yes.
letter E, provided that the property that's made the subject of a trust can be alienated at all under the lex situs, questions as to the validity and effect of placing such assets in trust, even though the assets are shares in a civil law jurisdiction, can be determined by the governing law of the trust. To put the matter in the context of this case, the declarations of trust will not be dividing the equitable and legal interests in the shares under Saudi Arabian law, that's not possible. Well, so far, so good. But the declarations of trust may give civil rights under the trust in respect of those shares that will have to be determined by the governing law of the trust, taking into account that under Saudi Arabian law, a division of equitable and legal interests is not possible.
Well, you're saying that's, now you see it, now you
I
don't.
say it's meaningless. I mean, you either take it into account or you don't.
Oh, see that.
Now, my last few minutes, could I please come on to Article 15, which I can deal with very briefly. It may be helpful to go back to Article 15, Authorities, Volume 1. MS 987.
$987.
987.
Yep.
We looked at it before.
Yes, we did.
The law, as you know, is defined in Article 17. The second sentence contemplates that Article 15 may have the effect of preventing recognition altogether, which would be its effect in this case if you are with us. And although the court is empowered to try to give effect to the objects of the trust by other means, no other means have actually been suggested. If I may please go to von Overbeck at paragraph 138, MS 1047, where he describes a relationship between Articles 4 and 15.
Which paragraph, sorry, you did say?
Paragraph 138,
Thank you so much.
MS 1047.
Yes, yes.
There's a typo in the first line. He says it will be for Article 3, and it clearly should be Article 4. Removes entirely from the Convention's coverage the acts done prior to the creation of a trust, which are necessary for its creation. To the contrary, Article 15 looks to those hypothetical situations in which an existing trust may deploy effects which are incompatible with the mandatory rules of the forum or of the law of a third country for a field other than trusts. The intent was to preserve above all the forum's substantive law in cases where its conflicts rules designated its own law, but this provision is also intended to preserve a foreign substantive law which is designed by the private international law, which is designated by the private international law of the forum. So, in very broad terms, I say that Sickles' case is snagged either by Article 4 or by Article 15. It doesn't obviously make any difference for my purposes, but it's one or the other. And it's sometimes called, it's been described as an escape clause. That's quite an important concept, this, because it highlights the role of Article 15 in preserving mandatory provisions of local law. If you go to AV2...
What do you mean by local law? I mean, there isn't any... The local law here is English.
Well, sorry. Sorry. Let me take the exact language of Article 15. It's the law designated by the conflict rules of the forum.
Yes.
Which may be.
Which is that?
Yes. I'm sorry, I used shorthand. I shouldn't have done. But
Well, sorry, but how do you get to Saudi Arabian law under Article 15?
because if the lex citus hasn't kicked in before or by virtue of Article 4, then then this forum must identify provisions of the law designated by the conflicts rules of the forum.
I see. So although,
Relating to-
yes, although effectively you've kicked out Saudi Arabian law at the first stage, and because otherwise you wouldn't get to Article 15, you now kick it back in.
Exactly, yes.
Yes. So you'd expect this to be a pretty exceptional situation, wouldn't you? You'd expect, I mean, it applies to mandatory rules. We have to look at what is meant by mandatory rules in private international law.
Yes, well,
Starting point, I think, is section 1(3) of the Act, isn't it?
yes. Section 1(3) of the Act, in this forum, if I may put it like this, beefs up Article 15.
Yes.
So,
Because the words "does not prevent" are a bit pusillanimous. I mean, it doesn't really tell you what you're meant to do with it.
I mean, it refers to an overriding rule which prevails over whatever arrangements the parties may have made.
Yes. But this is why it's sometimes called an escape clause. It's there to ensure that the convention doesn't go beyond a certain point. And if I could take you to AV2 tab 11 MS 1461. Very short paragraph, paragraph 126 of von Overbeck. Article 16 deals with renvoi. Articles 17 to 20 contain clauses, and that I should say Articles 16 to 20 are now 15 to 19. Contain clauses providing safeguards against the possibility of excessive application of the law of trusts.
Which do those articles correspond to the articles in the final version?
No, no.
15 to 20 is 15.
What was Articles 16 to 20 is now Articles 15 to 19.
So 17 to 20 is
16 to 19, and what was 16 is now 15.
taking into account section 1(3), could you just take me, at any rate, through Article 15 and explain how it applies in the present case?
Section 1(3).
Well, taking account of section 1(3), but then looking at Article 15, how does it actually apply in your submission of the present case? It requires the application of provisions of the law designated by the conflict rules of the forum. What are those conflict of laws rules?
Well, it's not, but the full phrase is the law designated by the conflicts rules of the forum, ... relating in particular to the following matters. So we're looking at the law designated by the conflict laws of the forum relating to the transfer of title to property.
So you say the relevant, so this is just this reinforces the lex situs rule.
Yes, absolutely.
No more, no less.
Well, it preserves it.
Well, yes. Requires its application.
Requires its application.
Well, they have to be provisions which cannot be derogated from by any voluntary act. So they are, as I put it a moment ago,
Yes.
have to be provisions which by their nature override whatever agreement the parties may have made.
Yes.
And what is the... and you rely in that context, do you, on the fact that Saudi law will not recognise equitable interests, equitable
Yes, I do.
interests, whatever the parties may have agreed?
Yes.
Yes.
I say it's a broad. It's a broad concept, a vision which cannot be derogated from by voluntary act, and there are there are rules of English law, such as that a contract needs to be supported by consideration, which they're not actually in a law as such, but if you don't provide consideration, you won't have a contract. It's that sort of provision. It's not a question of form, it's a question of whether the parties can depart from the provision.
But the rule, I mean, that's an example so far from the present case is difficult to grasp, but you can't regard the English rule that you can't have a contract generally without consideration as a mandatory rule in this sort of context, can you? Because parties are perfectly free to contract out of it by operating under French law.
Or under seal. Or under seal in English law.
Yes, or under seal. So, I mean, that's not what's meant by a rule which can't be derogated against. So, this is quite a sort of common formula in private international law, and it's intended to refer to a particular class of really fundamental policy-based rules.
Well, what's this in? Right, I better draw attention to tab, Authorities Volume 9, tab 94, page 3751. This is from a work called Autonomy in International Contracts by Peter Nigg. And at page 3751, there's a heading to what are mandatory rules. The term mandatory rules in English suffers from an inherent ambiguity. This is illustrated by the Convention on the Law Applicable to Contractual Obligations, which in Article 3.3 defines the English term mandatory rules as rules which cannot be derogated from by contract. This definition dominates Article 3.3 as well as Articles 5 and 6. In the situations where these provisions apply, the parties are bound by the rules of the legal system indicated, which they cannot opt out of. The description, of course, covers what Savini described as absolute laws. The common law rule, for instance, which requires consideration for a simple contract, i.e. not made by deed, to be binding, is a mandatory rule in this sense. Parties cannot, in a purely domestic English contract, exclude that requirement, but they can exclude it by choosing in a contract with sufficient international connections that
Yes, well, we were putting that a moment ago.
Yes.
Is it the next paragraph that's relevant? I mean, in what sense? The next paragraph points out that there is a different sense of mandatory rules, as I was suggesting. Aren't we using that different sense when we are in Article 15?
Well, that's the difference between Articles 15 and 16 of the Convention. The mandatory rules in essential lordship...
I see. Is Article 18, you say?
Yes.
I see.
Article 16.
16.
Sorry, 16. Yes, I see.
Yep.
And one more citation on that is Jonathan Harris, The Hague's Trust Convention, Authorities, Vol. 7, tab 77, page 332. 2322. There's a heading 3, domestic and international mandatory rules.
Yeah.
And the first paragraph under that is right in point. And there's one more reference I may give you without taking you to it. Overbeck, para 140, and that's MS 1047. Again, discussing the difference between mandatory rules and Article 16.
Which
That's von Overbeck, Authorities, Volume 1.
yeah.
At para 140, page 401.
Yep.
Page NS 1047.
So 1047.
Sorry, MS 1047.
So I didn't take the reference to Professor Harris down correctly, I think.
Harris was Authorities 7,
Yes.
tab 77, page MS 3322.
Is that the passage that the Court of Appeal cited, paragraph 60 of their judgment? Harris article.
No, I don't think it is. No, it's not.
Can I just go back to Lord Collins' question? I'm not quite sure that I've got clear in my mind the way you say Article 15 works. So you start with English law as the forum.
Yes.
You then, against the background that the putative law of the trust is, say, Cayman,
Yeah.
you say the relevant English conflict rule at common law takes you under D to Saudi law, and
Yes.
you say that there's a non-derogable provision of Saudi law which yields the answer in this case.
Yes.
Now, what do you say to the Court of Appeal's comments on this at 63 and, 64 in particular, 64 and 65?
Well, that's really where I was going to end my submissions. Because no, I say the Court of Appeal went wrong. If you look at paragraph 63, the Court of Appeal identifies, let me read. In this case, Samba contends that the 10th Assistant Chancellor ought to have held that 4 mandatory rules of Saudi Arabian law were applicable under Article 15. First, the rule that the 10th Assistant Chancellor did purport to apply, namely that applicable to disputed share title to shares. Secondly, the rule that no equitable title separate from legal title is recognised. Third, the rule that foreigners cannot own shares in Saudi Arabia and that fronting arrangements are illegal. And fourthly, that registration of shares in Saudi Arabia listed companies is conclusive evidence of title.
Now, so far so good. They have understood your case correctly. Have they not?
Yes. Now, just going back over this, points 1 and 2 are all wrapped up in the common ground. That's in the statement of facts
Common
paragraph.
ground.
paragraph
You
common
took us
ground,
to.
yes,
You
I'm
took
sorry,
us
yes.
to.
Yeah.
The provisions you took us to in the
Yes.
statement of agreed fact, yeah.
Point 3 is recited in the second share sale agreement that I've taken you to, and point 4 doesn't matter for my purposes. if I lose on 1 to 3, I can't win on 4.
Point 3 is what?
Point 3 is recited in the second share sale agreement that I showed you this morning. Now, in the light of my submissions on points 1, 2 and 3, I say that the point made by the Court of Appeal in paragraph 64 was not justified. And there was no need for a detailed and specific understanding of Saudi Arabian law beyond the way that matters are set out in paragraph 63.
Can we just look again, sorry, at the recital in the second share sale agreement?
Yes.
What page was that?
Yes, I just took the reference. It's MS341.
Thank you.
Core bundle 1, MS341.
Which recital is it?
It's
Different one, isn't it? Is it?
oh, sorry, have I got the wrong one?
not.
Sorry, it's 359. Sorry, I've got the wrong. Yeah.
Yeah.
And it's recital 3. Sickle cannot hold the legal title to such shares.
I mean, on the face of it, the agreed fact recorded in paragraph 17 of the Statement of Facts and Issues, there is no means of creating separate legal and equitable proprietary interests in property in Saudi Arabian law. You couldn't get anything more mandatory than that if the correct meaning of mandatory is that you can't derogate from it,
Yes.
as opposed to its being based on a fundamental public policy.
Yes.
Yep.
Let's go there. Paragraph 64, yes. Yes, in paragraph 64 of their judgment, this is just following up on Lord Thompson's question. Well, I think it's probably the same point as I've already made,
Yeah.
but it says there was no evidence at all before Lieutenant Excellency as to whether the rules of Saudi Arabian law in question were mandatory or not. In other words, whether there was anything stopping a Saudi Arabian citizen under Saudi Arabian law from declaring a trust of Saudi Arabian assets under a regime governed by another law. But on the agreed facts, I mean, it isn't that there was a law that says if you try and do this, you'll go to prison. It's just it's something you can't do.
It's just ineffective,
Yes,
so you're not able to derogate from it,
yes.
though nobody will put you in prison if you try.
Yeah.
If you can't do it in Saudi Arabia, which is the common ground, is that fatal to the case? Because, as I thought I understood, the effect of Mr. Howard's case is that while he accepts that it can't be done in Saudi Arabia, he says that the Trust Convention applies and a proprietary interest can be recognised in
Yes.
Cayman Islands or in the UK or in England. So that if that's right, there's no common ground that Saudi Arabian law in some way purports to prevent the recognition of a proprietary interest in England. Isn't that the point the Court of Appeal is making?
Well, I'm not sure it is, but even if it is, it's wrong. This is what I say. The convention cannot have been designed to allow that a foreign court, I say I'm talking now from a Saudi perspective, that an English court can declare a proprietary interest to exist under Saudi law when it doesn't exist under Saudi law.
Well, that may be the point of contention, whether, and Mr. Howe will explain, but whether he really is asking us to declare that a proprietary interest exists under Saudi law. He says, let us assume he accepts that in Saudi law terms, there isn't any proprietary interest. Nonetheless, he says that this is an area which belongs to the Trust Convention. You ignore the lex situs, and we're in England now, and we can see that applying the proper law of the trust, there is a proprietary interest, and we can give effect to that, whatever the lex situs would say. And if that's right, then there's nothing in Article 15, or at least there's no evidence necessarily that Saudi law would regard that as something that was impossible, even if one were to refer to it.
Well, that's a very fair way of summarising the competing argument.
I think your argument is that if you are right on the points of principle, there is no point in it going off to a trial in order to determine what is the character of the Saudi law, which on that footing is the relevant law, because there is agreement on the aspect of it that matters.
Yes.
This is a point that only arises if you are right in principle. I think you would probably accept that if Mr. Howard is right in his construction of the convention, the point you've just made doesn't arise.
Yes.
Well, I see the time, and so I can assist further to my submissions.
Thank you very much. Mr. Green, you've said all you want to say. Thank you very much.
Mr. Howard.
My Lords, as your Lordships know, Sickle is a Cayman Islands company in liquidation, the winding up having commenced in August of 2009. Prior to the liquidation, Mr. Al Sanir, its former director, had held very valuable shares in the Saudi banks as trustee. Now, in this appeal, Samba does not dispute that the respondents have an arguable case that each of the trusts was governed by Cayman Islands law. And it's our case that under that law, the 6 trusts were valid trusts of the shares, such that Sickle enjoyed equitable proprietary rights, which were property for the purposes of the Insolvency Act 1986. Now, the claims are made pursuant to the cross-border insolvency regulations as a result of the disposal by Mr. Al Sanir of the shares subsequent to the winding up. The effect of the regulations is that upon recognition of the foreign winding up proceedings, the English court, in summary, treats this as if it were an English liquidation with the same rights. Now, upon the winding up, therefore, a statutory trust was brought into operation on all Sickle's assets, wherever they were situated, both within and without the jurisdiction. Now, that's a point that is made repeatedly in the cases, and it's a point that's emphasised, we don't need to turn it up, I think, but in the Stichting, Shell and Crease case, where my Lords, Lord Sumption and Lord Toulson, explained the policy behind this aspect of the Insolvency Act, and essentially to preserve the pari passu principle. And so the respondents are seeking a declaration under Section 127 of the Insolvency Act that the transfer of the shares was void and associated relief. Now, essentially, having established that the disposition was void, Sickle will seek restitution or similar relief in due course. Now, Mr. Hapgood said at one point, the shares are frozen. I don't know why he says that. They're not frozen. It's the first time it's been suggested. And as I said, I think in answer to a point raised by Lord Mance, we recognise that we couldn't enforce in Saudi Arabia an order that they hand over the shares. Now, the debate in this court is about whether at the relevant time, that's at the time of the winding up, Sickle had any property for the purposes of the claim. And that is, we submit, an issue that where foreign law is only relevant because we're dealing with a Cayman Islands law trust. Now, Samba's answer to the claim is, for present purposes, a simple one, but we suggest one that's both curious and misconceived. Samba denies that the shares were ever part of Sickle's estate, and accordingly, its position, and it's important to note this, is that it does not matter whether and to what extent it knew that Mr. Al-Sanir had agreed to hold and had declared that he held the shares on trust for Sickle, because it says all of that was ineffective, and so it was free to take the transfer of the shares, irrespective of what it may have known about it. Now, Samba's case is that despite there being an arguable case that there were in fact 6 Cayman Island law trusts in respect to the shares, they say that is irrelevant because, they appear to say, the question whether Sickle acquired equitable proprietary interests in the shares as a result of the 6 trusts is not, they say, determined by the law of the trusts, but is determined by the lex situs. So they say there's a rule which is to that effect, an English conflicts of law rule. And the rule appears to be that equitable proprietary interests in assets can only be created if it's possible under the lex situs. So their case is that because Saudi Arabia has no concept in its law of trust, it is impossible to have created a trust, notwithstanding that's what the settlor intended and provided, namely that he provided for Cayman Islands law trusts. So that what one is left with is the stark proposition that it is not possible, by means of a common law trust, to create proprietary interests in property, that's equitable proprietary interests, in property situated in a state whose law does not contain the common law trust concept or the notion of equity and equitable interests, even though those rights are fully recognised under the law governing the trust. So it would appear that this is, as I've said, through the application of a conflict of law rule, the precise definition of which is unclear, but it's a rule which requires the court to disapply that which the settlor intended, namely the law of the trust, and simply say that no trust can be created where the asset is located in a non-trust jurisdiction without, which doesn't contain this concept. Now, the structure of the argument is that Samba seeks to invoke the alleged conflict rule via Article 4 of the Hague Convention, which it says somehow mandates the application of the alleged rule. Alternatively, it says if it's wrong about that, and so Article 4 doesn't provide the route, it says it can get there via Article 15, which it says overrides the application of Cayman Islands law and leads to this alleged rule. Now, in our submission, each of these propositions is fundamentally wrong. And before one gets to consider the convention, what you can see lies at the heart of Samba's arguments is the alleged common law conflict rule which I have just described. Now, in our submission, this is a fairly startling proposition. The establishment of common law trusts over assets situated in a non-trust law country, and one that contains no such concepts of trust, is an everyday occurrence for both private and commercial corporate finance purposes. And when we were in front of the Court of Appeal, I don't know whether your lordships have the second part of the appendix, which has the transcript of the Court of Appeal, but it is interesting to just see what the reaction of their lordships in the Court of Appeal was to this, particularly Lord Justice Voss, who is obviously an experienced trust lawyer. It's at page 101.
That's at the bottom, is it?
I'm sorry, my lord?
That's 101. Is that contain pages 8 to 11?
Yes, that's
Thank
it.
you.
And on the left-hand side, which is page 9,
Yep.
if you go to the foot of the page,
Yep.
at line 19, where I said that about the Chancellor, I'm afraid, notwithstanding the eminence of the judge below, I'm going to be suggesting that it's just fundamentally wrong and that Honeman nods occasionally, and that's what's happened here. Lord Justice Voss said, you go so far as to say it's absolutely barking. And I said, I would say it's barking, yes, I'm afraid. And Lord Justice Longmore said, let us say startling rather than barking. And I said, my language was startling.
Rather than barking.
Yeah, but I think I'm allowed to accept the invitation of my lord. Lord Justice Voss is correct. So the words fall from my lord and not from me. And his lordship then said, in its effect, not as to the law, and in its effect, it would be absolutely remarkable. And in my submission, Lord Justice Voss's reaction to what is being said here is right, that it would be remarkable and startling if it were the case that it is impossible to have a common law trust over an asset which is situated, for instance, in France.
Well, I don't actually think that that's quite what's being suggested. Nobody doubts that the creation of a trust may be effective to create personal obligations on the part of the trustee.
Yes.
And in many circumstances, that may be good enough. In some, it will not be. It's the situation which exists effectively in all civil countries. The point that I think is being made is that while you can transfer or deal with, under any proper law you like, rights that actually exist, the question whether a particular kind of right is capable of existing is not a matter of agreement, but of positive law. You therefore have to ask yourself, who is positive law? And it's difficult to point to any other positive law that could determine whether a right is capable of existing other than the lex situs.
Well, that's, with respect, the problem with that is actually understanding what a trust is. The whole nature of a trust, and the reason it gives you what's described as an equitable proprietary interest, is that you have a personal right, but it's a personal right which allows you to compel the trustee to do something in relation to the property.
Yes.
And that's the whole nature of it. Now, I can understand the argument that one says, we don't recognise the trust. What you can't do is divide it up and say, well, you get what you've got here by the Declaration of Trust are personal rights, but not, where it's, say, governed by English law or Cayman Islands law, not actually the whole purpose of the trust, which is to give you these equitable rights to compel the trustee to perform in a particular way.
Well, I don't think there's any doubt that you can exercise personal jurisdiction over the trustee to compel him to act in accordance with the trust he's assumed under whatever is the relevant proper law, that obligation. But if the question is, what proprietary rights exist,
Yes.
you have to identify some law which determines what rights are capable of existing. The parties cannot, by their dealings among themselves, create a species of right that has no existence in the relevant positive law.
Well, with respect, I would say that one's got to divide out two different points that arise in this litigation, as the point I was making this morning. There's one issue, which is what we're currently debating, which is whether or not interests were created in the first place. In other words, whether a trust was created. There's a separate issue, which is when Samba acquired the shares in Saudi Arabia, what is the effect on the interest that has been created in the first place? In other words, can Samba defeat the interest by saying, well, I acquired these shares in Saudi Arabia, and Saudi Arabia doesn't recognize your interest, and so I've taken free and clear. That's an issue that will have to be debated at a second stage. But when you're at the first stage, in my submission, there's absolutely no reason why between the parties you can't create the interest. That the lex citus doesn't, as it were, the law of property doesn't trump the law of trust, and that you can, under the trust, create this interest.
Your point is perhaps, I mean, why is one so fixated on the lex citus of the shares?
Exactly.
Why?
If you create a trust, you've got all the...
It's very common. In fact, I think it's the case in this jurisdiction that companies are not interested in the beneficial interests of shareholders. So, and I said, does your argument, or can your argument be put on the basis that trust is, although it creates a type of property, it's a type of property which isn't necessarily dependent upon the location of the shares in which the interest is. It's an independent type of interest, a proprietary interest. Is that a possible way of putting it?
It's in fact a trust. The rights you get in a trust are actually in personam rights which are against the trustee, but because you can enforce the trustee, require him as a matter of specific performance to do something with the property, that's what we treat as a proprietary claim. We treat that equitable interest as giving rise to a proprietary claim.
Yes, I mean, the problem is that we treat it as giving a proprietary interest in the underlying shares.
Well, that's right. I mean, that's why it matters.
Okay. Do you quarrel with the proposition, the Macmillan proposition, that the lex citus of the shares is the by parallel with movables? Because there has been academic controversy. I know Professor Rogerson wrote an article some years ago quarrelling with the lex citus, saying that there were lots of defects when you applied it to intangibles.
I mean, our essential point for the purposes of this appeal is that Macmillan's got nothing to do with the issue that we're debating. Because this isn't at this stage, it's not about, Macmillan was a case about priorities and about title to the shares, and it's not about whether somebody had an equitable interest.
No, quite.
And that's why we say...
You've still got the problem, since an equitable interest in shares, and since the shares, unless you quarrel with us, are in Saudi Arabia, that you get the problem of asking, well, where is the equitable interest cited if it's not cited in Saudi Arabia? I mean, it is slightly odd to talk of it cited in Saudi Arabia, but...
Well, let's take a simpler example. Let's say you've got a house in Saudi Arabia and you and I agree under a contract that you'll sell it to me. And our contract is, we expressly agree to be subject to and interpret to and subject to English law. Now, English law would say a contract for the sale of land involves the creation of a trust, rather odd trust, but a trust, by the vendor in favour of the purchaser. Now, subject to the provision not being recognised as the English law provision not being recognised in Saudi Arabia, it may be a perfectly valid contract in Saudi Arabia. But do you say that the trust is created thereby, which it would in English law?
I would say there is a trust if you've said it's all governed by English law. Now, of course...
In what sense? Do you mean that in the sense that the English courts might compel by injunction the trustee to act in the way that a trustee is supposed to act? Or do you mean that it is effective in the sense that there is this land in Saudi Arabia in which you have a right of ownership.
I mean, in the former sense,
Right? Well, that's uncontroversial, I would have thought.
well, but the former sense is sufficient for me to establish my interest.
A proprietary interest?
Yes. Because that's all a trust
How
ever...
can it be a proprietary interest?
Well,
If somebody knowing of the existence of the trust, if a Saudi Arabian knowing of the existence of the contract purchases the property from you, knowing of my interest in law, would he take subject to my interest? On your argument, he would, even though Saudi Arabia doesn't recognise
well,
my interest.
the answer to that in that it is, and I'll show you some of the authorities. What the authorities suggest is that in the normal case, in the example that you've given, that where the transfer of the property takes place in a foreign jurisdiction which doesn't recognise the trust, that the purchaser who takes the property does so free and clear, even if he knew of the equitable interest. Now, but the question that will arise in this case is what is the effect of the insolvency regime and the effect of the Insolvency Act, which provides that any disposition is void unless validated. The question that will arise in this case is when you get to the validation stage, and that's actually, in that sentence, which I think your lordships were critical of in the Court of Appeal, that's actually what they're talking about. I think it's in the last sentence of paragraph 55. I think.
Well, before we get there, I must ask this question, which is troubling me, because you keep referring to at this stage.
Yes.
And I was looking at the statement of issues in conjunction with your answer to Lord Sumption's question about whether it might be effective as between the sickle and the trustee. And I'm rather concerned that you may be inviting us to answer an incredibly narrow question in the light of what you've just said in the statement of issues, which is what's the position as between sickle and Mr. Al-Sena?
Yes, well, that is the only issue that...
I think you go further, because at least you did a moment ago, and say that because, as between Sickle and Mr. Al-Seni personally, there is the obligation of a trustee, the personal obligation of a trustee, it follows that there is a proprietary right. So you go back round in circles and come back to the position which you originally escaped from because you saw it was prohibited. As I understand it, you are saying not just that there is that the trust creates the personal obligations of the trustee. You are saying, and therefore, because this is the consequence in English law, there is a proprietary right.
Well,
the latter is just as important a part of your case as the former.
Yeah, no, sorry, if I hadn't made that clear, of course, the whole debate is dependent upon whether I establish property as defined in the Insolvency Act.
Yes.
That's the issue.
Which you deduce from the existence of the personal obligations of the trustee.
Which we say we deduce from the fact that Mr. Al-Sania declared that he was a trustee over the shares. That was sufficient to give us an equitable interest in the shares, and that equitable interest amounts to property under the Act. And that's the only, to respond to my Lord Collins' question, the reason we are here is because it has been argued by Samba that doesn't arise, that we never got any form of equitable interest as a result of that declaration of trust. So that we haven't got to the stage where they say, well, even if you did, I can trump it because I got good title in Saudi Arabia. No one has investigated that issue at the moment. And that's what would happen if we go on to a trial. And that would be pleaded out and so that we know what
we have to ask ourselves, don't we, what is the nature of a proprietary interest? And one way of testing that is whether, consistently with its existence, the property can, in principle, be transferred to a third party with notice. I mean, that is inherent in the whole concept of equitable property. and we can't therefore discuss the concept of equitable property without reference to it.
Well, I have some sympathy for that, but that isn't the way in which the case has so far proceeded.
I'm not sure about that. I mean, this is just an ordinary legal consequence of describing something as equitable property.
Well, there's that consequence, but you also got added to it is the effect of the Insolvency Act. And what is the effect where the Insolvency Act says that a disposition of the company's property is void, subject to validation. If we establish this is the company's property, in that the company had a right in relation to the shares as a result of the trust, then in our submission we've established the first limb, and everything else will have to be considered at a later stage. Now, I fully accept your Lordship's point that if you haven't got anything which is capable of amounting to an interest within the statutory definition, which is the argument, then you fail. But we're not at this stage, well, I've already made the point, considering the circumstances in which Samba acquired their interest.
That would mean, if you're right, all these issues will all have to be virtually relitigated.
Well, an awful lot of this may well end up being relitigated. I mean, it's one of the points, for instance, the Court of Appeal made about when dealing with the mandatory provision or non-derogable provision, that the evidence wasn't sufficient to identify whether, in fact, there was some non-derogable provision.
Because what conflict of law rule, if any, assuming you're right on stage one, which is as between you and Mr. Alsania, what conflict of law rules apply as to whether Samba is bound by notice?
The issue there will be the application of the Insolvency Act, because we say, for the purposes of the Insolvency Act, you're looking that there's an international reach for insolvency, and so the court is entitled. It may consider whether they were bona fide purchases for value without notice. That may trump our right. If they weren't bona fide, the court will have to consider, well, is it sufficient to validate this that they were in Saudi Arabia? In other words,
yes. Does that mean you're saying that once you succeed at stage one, the only question then is a question under the Insolvency Act, and there are no conflict of laws rules as against Samba?
Exactly, subject to the Article 15 point, which the Court of Appeal, our submission is that the Article 15 doesn't arise in this case at all, because Article 15 is not concerned with the situation, the first stage at which the trustee acquires the property. It's concerned with downstream matters. And but subject to that, if I'm wrong about that, then a potential issue arises as to whether there was some mandatory provision of Saudi law.
Well, how does that, the way you just put it before, how can that arise? Because you say that if you're right on stage one, which is that there is some sort of property for the purposes of Section 127, not necessarily for any other purposes, you're through. Why do these rules then, how does Article 15 kick in at the next stage?
My submission is it doesn't.
What you were just saying?
No, I'm saying if I were wrong,
Yes.
just to get it, got to remember the way Article 15 is being used by Samba is they say the initial stage at which, I'm just trying to use their language, at which the trustee acquires, or not acquires, but the initial stage at which the trust is created, they say that is outside the convention and you apply the lex situs rule. If they're wrong on that, they say the lex situs rule comes in relation to that same question through Article 15. Now we say it doesn't. Article 15 is not concerned with the transfer, if there is a transfer of property to the trustee, or with a declaration. Article 15 is concerned with other things. But if I'm wrong about that, and the Court of Appeal appear to have proceeded on the basis that Article 15 could apply, then in that situation, one would have to investigate what Saudi Arabian law says. But our primary submission is that if we're right in front of your lordships, then after this there won't be any further conflicts of law issues at all. We would go on to have an investigation as to whether or not Samba was entitled to validation, if that's what they say they are entitled to.
It's rather unfortunate that with a statement of facts and issues, the end of a full day's argument with parties represented by immensely capable people, there seems to be a disagreement as to what the appeal is about.
I don't think there is a disagreement.
Well, can I check one thing? The
Disagreement as to whether there's disagreement.
appellant's case, paragraph 5, where they set out what they say is the central issue of law raised by the appeal. Do you agree or disagree?
The way it's put there in our submission what is not actually the reflection of the way the statement of issues was put. If you go back to MS page 70.
Which paragraph?
Well, it's paragraph 27.
Paragraph 27 of
Yeah.
SFI. Yeah.
And it's quite interesting to remember that was, the question was at 4A, was do the transactions give rise to any preliminary issue such that the convention does not apply to those issues? And if the answer is yes, at common law, which law determines those issues, and what is the effect of that law in relation to the
7 paragraphs.
the 6 transactions?
I got it. Thank you very much. Yeah.
Well, it seems pretty clear what both courts below thought they were deciding,
Yes.
which bears a fairly close resemblance to the way it's formulated in paragraph 1 of the appellant's printed case.
Paragraph 1.
Paragraph 3.
Or paragraph 3, sorry.
Sorry, my fault. Paragraph 5.
Yes. Well, so yeah. No, sorry, I'm rereading it, and I apologise. I missed. I don't have any difficulty, in fact, with that question.
I thought you did, because I don't think before you were really, the substance of your argument really agrees with the phrase disposition.
Well, it's
Creation.
It's the creation of, we say, what it's. It's really the creation of an equitable interest on the establishment of a trust, determined by the lex situs of the property or the putative governing law of the trust. That's actually.
But it's the proprietary interest we're concerned with, is it? Do you agree with that or not?
Well,
or do you think is that putting it too narrowly?
Well, it's. Sorry, when your lordship says the proprietary
Property rights, is it the creation?
It's the way in which this has been phrased, and the way obviously the appellants are interested, is they want to say that what is happening is a disposal of a property right.
Or a creation. I don't think it makes
I don't think it matters.
Yes,
That way.
but
Agree.
but it's drafted in a way which is intended to lead to the what they say is the lex situs rule, whereas we say that the correct formulation is.
There's essentially, where there's a trust, the relationship between the trustee and beneficiary determines the situs of the proprietary right created, or a proprietary right created by the trust.
Yes.
That's sort of
Well, essentially, yeah.
Well, it's 3:45, and I threw a spanner in the works by asking this question, but I was quite keen to know what you said the case was really about, and we appeared to be getting into some quite complex territory. May I suggest I don't interrupt your development of your case, but possibly overnight you could, both of you, see whether you can agree on some version of paragraph 5 because I think you're not a million miles away from each other, rather than us use up your valuable time on suggesting alternative words.
Yeah, well, okay, I mean, going to say, what we have said, the way we have put it is that we say the question is whether it is possible, by means of a common law trust, to create equitable proprietary rights in property situated in a state whose law does not contain the common law trust concept or the notion of equity and equitable interests. And that's what we say the question is, and that was the question we say effectively that was being answered by the Court of Appeal. I mean, what the Chancellor said, the answer to that is no, because the lex situs applies and everything gives way to that. And the Court of Appeal essentially said that the rule in Macmillan has got nothing to do with the creation of equitable interests via a trust. And that's really the dividing line between the parties on the fundamental point.
Because their enforcement is effectively personal.
Yes, that's exactly the point.
Equitable proprietary rights is really shorthand for equitable interests or equitable relationships which have proprietary effect.
They have proprietary effects, but when we look at the cases, one will see that, and I think in one of the cases it said, well, when ordering the trust, when giving effect to the trust, one's not trying to effect anything that would be done in the foreign jurisdiction, recognising one can't do that. Be up to the trustee whether he does what is necessary. But you have because you have jurisdiction over him, you can give effect to the trust. And if we just think about this case for a moment, and take Mr. Al-Sanir, just when forget the transfer to Samba. The argument that is made here is that vis-a-vis Mr. Al-Sanir, one couldn't have had actually any proprietary rights either of this type. I mean, assume Mr. Al-Sanir came to this country and became bankrupt. Exactly the same argument would be arising as to whether the shares were Sickles shares or whether they were available to Mr. Al-Sanir's personal creditors. And in our submission, that would be a classic example where equity would be able to enforce the trust, because he was here, and one would say, therefore, the fact that the shares were in Saudi Arabia would be completely irrelevant.
I suppose similarly, if he gave the shares to his wife, who knew all about the trust, the question would arise whether there was any right or if he gave property in some jurisdiction which doesn't recognise a trust. He said, I've given it all to my wife. The question was whether you could have any remedy against that.
That's right. I mean, the consequence of what is being said here is that one would have no remedy at all. I mean, you might have a remedy in damages against Mr. Al-Sanir, but you wouldn't have a remedy you wouldn't be entitled to go against his wife on the basis that she was holding the shares now as your constructive trustee, because you never had any equitable interest in the shares in the first place. So now, our submission in answer to these propositions is firstly that there in fact has never been a problem with creating a common law trust over an asset in a jurisdiction that does not know the concept of trust. And a court of equity is able to exercise jurisdiction to give effect to the trust. And so we say there is no conflict rule that requires the court to displace what the parties have agreed. Secondly, we say Article 4 of the Convention is not applicable, as there is no preliminary issue in this case relating to a transfer to the trustee. Thirdly, we say, in any event, that the only effect of the application of Article 4 would be to take one back to common law conflict of law rules, and we say those would recognise the trust. So that the debate about Article 4, we suggest, is an arid one, unless Samba's alleged conflict rule exists, which we say it does not. As to Article 15, we say that has no application here, and it's concerned with matters other than those relating to the issue of the validity of the trust. But even if it did apply, it would only be relevant if Samba could point to a conflict of law rule which mandated the application of a mandatory provision of Saudi law. And we say Samba can point to neither a conflict of law rule nor to a provision of Saudi law that cannot be derogated from by voluntary act. And in our submission, the result achieved in the Court of Appeal, which held that the trusts were effective, is not at all surprising. The Hague Convention was designed to ensure that trusts were recognised and given effect by non-trust states, particularly, and I'll show you the travaux on this, because of the frequent presence of trust assets in their jurisdiction. And in our submission, it would be contrary to the whole purpose of the Convention to say that its effect was that this court should refuse to recognise and give effect to a common law trust simply because the trust assets were in a non-trust state. Now, turning to the question, more fully to the question of whether a common law trust can be created over assets situated in a non-trust state, we referred in our case to Ewing and Ewing. Perhaps in the light of the debate we've had, it is worth just turning that up at A4, tab 32, pages 2232.
Just while we're doing that,
Yes.
I wonder whether your question is too wide. Supposing an English owner of shares in a Saudi company dies having left them in his will on trust for his widow and children and so on. I don't imagine there'd be a difficulty his personal representatives administering that. And I don't imagine Saudi law would have any problem in recognising that the administrator was the owner of the shares. What he had to do with them after that would have been no relevant concern, I would have thought, to Saudi Arabia. So a question, can you create a trust over property in a non-trust state? I suspect just too wide. We were actually concerned with a rather narrow issue.
I'm not sure I see how the issue is narrower.
Well, I think what we're concerned with here is whether this person in Saudi Arabia can not give the legal estate at all to the transferee, but can settle on the transferee an equitable interest only.
Well, is Your Lordship saying this arising at which stage of the inquiry? At the Article 15 stage?
I'm just a moment reflecting on the broad formula that you're advancing, and wondering whether that isn't overbroad.
Can I reflect on that
Of course.
overnight? I was going to go to Ewing and Ewing, and that's at tab 32. And as you can see from the head note, the testator was domiciled in Scotland. That's page 2232, possessing a large personal and some heritable property in Scotland and a small personal property in England. By will made in the Scotch form, appointed several persons to be executors and trustees, some of whom are in Scotland and some in England. And then skipping down a bit, an infant legatee resident in England brought an action to administer the estate. and there was a question of whether or not the court had jurisdiction, which it was held that the English court did have jurisdiction. The relevant passage, though, is at page 2238 to 9, and the well-known passage where they were dealing with the question of jurisdiction, and towards the foot of the page, the courts of equity in England are and always have been courts of conscience operating in personam and not in rem, and in the exercise of this personal jurisdiction they've always been accustomed to compel the performance of contracts and trusts as to subjects which were not either locally or ratione domicilii within their jurisdiction. They've done so as to land in Scotland, in Ireland and the colonies, in foreign countries, and authorities provided, a jurisdiction against trustees, which is not excluded ratione legis rei citae as to land, cannot be excluded as to movables, because the author of the trust may have had a foreign domicile. And for this purpose, it makes no difference whether the trust is constituted inter vivos or by a will or mortis clause a deed. Accordingly, it's always been the practice of the English Court of Chancery to administer as against executors and trustees, personally subject to its jurisdiction, the whole personal estate of testators or intestates who have died domiciled abroad, and then the Appellant's counsel were not able to produce any precedent for administration decree limited to assets locally situated within the jurisdiction. And the essential point is that the court can enforce a trust over assets which are abroad. And the same point is made by Lord Blackburn at page 46, the first complete paragraph on the page, where he says in the second sentence, the jurisdiction of the Court of Chancery is in personam. It acts upon the person whom it finds within its jurisdiction and compels him to perform the duty which he owes to the plaintiff. And at the bottom of the page, at 2244, he says, the last complete sentence, I do not agree in thinking that the order should, or indeed could, if made, be confined to that part of the property which is in England, or which was obtained by virtue of an English probate. As was pointed out by the Vice-Chancellor Kindersley and Innes and Mitchell, the trust is an entire trust as to all property. So that is authority to show that there's no problem in having a trust over foreign property. A good example in the same not in the same bundle, in Authorities Volume 1 at tab 4 at page 1062 is the Jewish Colonization Association case, which case concerned...
Sorry, can you give me the reference?
I beg your pardon. It's Authorities 1, tab 4, and it's MS page 1062, my lord. And the case concerned a settlement by an Austrian citizen resident in Paris of largely foreign securities, especially shares in European banks. And if you go to, in Lord Justice Collins, page 1075, the sentence beginning midway down the page, in this case, the inference, as pointed out by the Solicitor General, of intent on the part of the Baron, who is the settlor, to substitute the law of another country for that of his domicile is irresistible, when we find him not merely choosing an individual of his own domicile, but going out of his way to call into being a persona incapable of existence, except as a creature of English law, and then by an instrument not in his own language, but in English and in English form, making it the trustee for carrying out his purpose. And then if you go over the page, after quoting various cases, the first sentence on that page, I think the principle at the bottom of these tests is really the same, and whether we arrive at the conclusion that it has become English property because an indelible incident of English property is stamped upon it, namely that rights thereto should be ascertained by English law, or conclude that being English is therefore subject to our law, the result is the same. In either view, it's quite immaterial where the property is physically situated. What that's saying is, effectively, once you create an English law trust, either that of itself is what amounts to English property, and that's, so he says, it has become English property because it has an indelible incident of English property stamped upon it, and the right should be ascertained by English law, or because it's English, it's subject to our law, the result is the same. And in our submission, that is entirely inconsistent with some idea that an equitable proprietary interest of the right created by a trust it can only arise where the lex situs of the asset allows it. Now, to similar effect, in the same bundle...
Well, this is, just trying to understand.
Yes,
this was, the appellants were a company. Well, yes, they became entitled to succession, and the question is whether the property in question had an English character. It was, for the most part, it appears, situated abroad, if you look at the foot of 1064. So, I mean, if you took this general language, you say it shows that under an English trust of foreign property, the property in question can be regarded as English.
Exactly.
Was there anything in this case which depended on the distinction between personal and proprietary rights? In other words, was it necessary to the resolution of this case to establish that there was actually a proprietary right as opposed to a right to compel the executors to behave in a particular way?
The answer is, I don't think so, no.
It had to be property.
I'm sorry?
It had to be property under the Succession Duty Act.
Yeah, sorry, that is right. No, so in fact my answer is wrong with the point Lord Collins has made, that actually was the whole issue as to whether or not the tax was payable. It would only be payable.
Because it was succession of property. Where is the statute?
It's quoted at the top of 132,
Yeah.
maybe somewhere else.
And exactly the same point, I think, arises...
Every
in the,
disposition of property.
yeah, and exactly the same point arises in the Duke of Marlborough's case, I think, which is also concerned with, effectively, I think, succession or estate duty. But the Succession Duty Act is set out there at 132. And the Duke of Marlborough's case is in the same volume, A1, at tab 8.
Page?
It's page 1219, my lord.
Yep.
And again, this concerned whether succession duty and estate duty was due on assets held by trustees of a marriage settlement in consequence of the death of an English husband. The assets were American securities or shares, which had been settled by the American wife's father, and whether succession duty was payable depended on which law governed the settlement. And Lord Green, the Master of the Rolls, at 1222, his judgment starts, and he explains there that the first question that arises on this appeal is whether or not the death of the 9th Duke of succession duty, whether or not on the death of the 9th Duke, succession duty and consequently estate duty became payable in respect of the American securities held under one of the settlements executed on his marriage to Miss Consuelo Vanderbilt. And if you then go to 1223, there's a paragraph halfway down that begins, the examination starts with Wallace and the Attorney General, and his lordship sets out a passage from that, and after that, after quoting from the authority, he says, if this language is carefully studied, it's apparent that Lord Cranworth, in Wallace, was thinking and thinking only of the law which confirms the title, was not thinking of the court in which the claim to the title is to be enforced. In the case of a testator, it's the law of his domicile which governs the construction of the will and the validity of its disposition. It's by reason of that law that the beneficiary claims title, whatever the forum may be in which he makes his claim. The law by virtue of which a person claims title and the forum in which he claims it are two quite different things. The forum may be that of a country by virtue of whose law the title is claimed, or it may not. The claimant may not even have a choice of fora, but whatever forum has jurisdiction, the law by virtue of which title is claimed remains the same. Scillicet, the law of the domicile. If the principle laid down by Lord Cranworth in the case of wills applied in the case of a marriage settlement, the result does not appear to us to admit of doubt. In the case of a will, the law under which title is claimed is the law of domicile. In the case of a marriage settlement, the law under which title is claimed is the law which governs the settlement. The law can only be the law by reference to which the settlement was made, which was intended by the parties to govern their rights and liabilities. In other words, the law governing whether or not the beneficiary obtained an equitable interest in settled property was determined by the proper law of the trust, and not by some other law, such as the lex situs. Now, in the result, Lord Green found that, notwithstanding that it exclusively comprised foreign property, the settlement was governed by English law.
But there was no issue in this case, as I understand it, or in the others, as to whether the interest that the parties had created was capable of being created.
No, that's perfectly right, except this case was a case about securities in the United States, so obviously, or not necessarily, but largely in a common law country.
Yeah.
But at page 1227, his lordship there refers to the case I just showed you, which was the Attorney General and the Jewish Colonization Association, and there he endorses the view in that case, and you can see and there, of course, you were talking about assets which were situated in a civil law jurisdiction, and in the middle of the paragraph it says the settlement was written in the English language and was in English form, similar to our case. The company was one which, apart from formal matters, conducted its business from its office in Paris. The death of the donor, when duty was claimed, the greater part of the investments were foreign, only a small proportion were British. Speaking of this case in Attorney General and Bellios, Lord Justice Sargent points out it would not have been necessary for the court to apply foreign law for the purposes of the administration. There was, he said, a duly constituted English trust to be administered as such, though the origin of the constitution of the trust has been foreign. This, in our opinion, places the decision on the correct basis, namely the proper law of the contract, which was undoubtedly English. And I'd also suggest that page 1228 is relevant. And essentially what it is saying is that it is in relation to a trust, the parties can themselves determine what law applies and create the trust, and it's the trust.
Any interest in property which exists can be disposed of by will, contract, or other private transaction. That's what it shows. But the premise is that it exists.
Well,
which was not disputed in these cases.
So when you say the premise is it exists,
the interest in question was one that was capable of existing, or at least nobody was suggesting.
Nobody was suggesting otherwise, but the given is the fact that it's, the Lordship is right if you say, well, did parties argue as to whether or not you could have a trust where the asset was in France, and could that give rise to proprietary interest? Nobody said, well, the fact that it's in France means you can't, but because it simply didn't occur to anybody, it didn't occur to any of the judges, that that was an impediment. And the whole case is proceeded on the basis that that isn't a problem.
Is that a convenient moment?
Yes.
Thank you very much, Mr. Howard. We'll resume again at 10:30 tomorrow. Court's adjourned.